Widespread legal failure by a government is often attributed to bureaucratic incompetence, the image of underfunded agencies or overwhelmed staff stumbling through the legal process. However, looking at the mechanics of state litigation reveals a different reality. Systemic state failure in court can be a strictly rational, mathematical equilibrium. We can observe this economic phenomenon within the Punjab and Haryana High Court, a jurisdiction that provides a clear empirical ecosystem for studying these disputes. This dataset tracks land acquisition disputes from 2010 to 2011, where owners rejected the state's compensation offer. The third column shows the discrepancy with the High Court's final award. On average, the court increased compensation by over 290%. A near 300% discrepancy indicates a structural collapse in the state's bargaining power before a judge. The fundamental power dynamic here involves a government acting as the acquirer and a private citizen as the owner. Their interaction begins at time 0, establishing the asset's market value. At time 1, the state issues a take-it-or-leave-it official offer. The owner faces a binary choice: accept the valuation or reject it to enter litigation at time 2. At time 2, the court award is a stochastic distribution, depending entirely on evidence produced during trial. Both sides exert effort to influence the court. We label the owner's effort as X and the state's effort as Y. Because the final payoffs are determined by the relative intensity of these two variables, the party with the stronger incentive to exert effort dictates the legal outcome. During litigation, both sides solve a maximization problem, weighing the cost of producing legal evidence against the expected payout. The owner's lawyer captures the direct upside of their effort. Every extra rupee awarded is a direct gain. But the state's equation introduces lambda, the relative incentive power of the government lawyer. State representatives are typically salaried bureaucrats. They do not capture the financial surplus of a legal victory, meaning they lack the same direct incentive as their private sector counterparts. Consequently, lambda is always less than 1. The state's incentive to invest effort is mathematically a fraction of the owner's. The first-order condition shows that as lambda approaches 0, the optimal state effort also approaches 0. The Punjab High Court observed this in practice, noting that state counsels frequently failed to produce rebutting evidence, often attending court only to mark their presence. The current compensation structure makes 0 effort the only rational choice for the state's legal representatives. This asymmetry explains the trial outcomes, but the state's initial offer at time 1 is also structurally skewed. A government assessing officer prioritizes institutional safety, strictly following protocols to avoid personal liability, future audits, or accusations of corruption. This leads to the use of rigid assessment proxies, where artificial circle or registry rates are prioritized over actual market data found in sale deeds. Government manuals mandate these lower, outdated circle rates as a defensive, safe play mechanism for the bureaucrat. This reliance ensures the initial offer will fall significantly below the true market value that a court will eventually recognize. Bureaucratic self-preservation guarantees the initial offer is rejected, forcing the state into a legal battle it is not incentivized to fight. Institutional rigidities further complicate the state's position by removing the risks typically associated with litigation. The doctrine of prohibition of reformatio in peius, or Section 25 of the 1894 Act in India, protects the appellant from a worse outcome. Under this rule, a court is legally barred from awarding a compensation value lower than the state's initial executive offer. We model the probability of court awards as a curve. The state's initial offer is marked by a vertical line. Legislation truncates the left side, removing any possibility of a lower award, leaving only positive outcomes for the owner. Mathematically, this truncated integral ensures the expected value of an appeal is always greater than the initial offer. By legally eliminating downside risk, the state transforms litigation into a risk-free venture for the citizen. The logic of this land acquisition model, where the state's lack of incentive dictates the outcome, mirrors other areas where citizens and government negotiate over value. We can apply the same variables to broader regulatory fields. If we redefine X as the effort a corporation puts into tax evasion or non-compliance, and Y as the state's investment in audit, investigation, and regulatory enforcement, rational actors calculate their compliance based on the state's low lambda. They understand that a salaried auditor may not have the individual incentive to match the investigative effort of a well-funded private legal team. If the shadow of litigation is too weak to create a credible threat of enforcement, the incentive for voluntary compliance diminishes. When private actors know the state's enforcement capacity is structurally capped, the regulatory equilibrium shifts towards low compliance and depleted state revenues. A common policy response to low compliance is to increase statutory penalties and fines. This model suggests that approach is inefficient. High penalties have little impact if the probability of state enforcement, the Y variable, remains near zero. Addressing the imbalance requires reforming the institutional architecture itself. This includes adjusting asymmetric protective doctrines that truncate risk and lead to overwhelmed court systems. It also requires restructuring how state enforcement capacity is financially and professionally incentivized to close the lambda gap. Correcting the economic incentives governing state bureaucrats is the necessary first step toward effective regulation of the public.